Welcome to The Explainer. All right, if you've got law exams coming up, this one is for you. We're doing a high-impact revision session on the core principles of the Indian Contract Act of 1872 to really help you nail those answers. So here's our game plan. We're going to hit 4 absolutely crucial topics, looking at them through some practical exam-style problems. Then we'll wrap it all up with a rapid-fire recap of the key sections you have got to know. Okay, first up, let's look at something that comes up all the time in real life, a broken social promise. Now, this poses a really fundamental question, right? Does a casual invitation, a social plan, actually create a contract that's legally binding? It sounds a bit silly, but let's see what the law actually has to say about it. So the whole thing hinges on this one crucial principle, legal intent. For an agreement to become a contract, both sides have to intend for it to have legal consequences. And the law just presumes that for social or family arrangements, that intention is missing. The landmark case you absolutely have to cite here is Balfour versus Balfour. It's the classic authority that says these kinds of promises belong in the home, not in a courtroom. And that leads us to a clear conclusion. Since there was no intention to create legal relations, there was no contract. And if there's no contract, there can't be a breach. So unfortunately for B, that taxi fare is not something they can legally recover. Okay, let's move on to our second big topic, the whole dance of offer and acceptance. This is where we get into the nuts and bolts of how a contract is actually born, or, as we're about to see, how it can fail to ever come into existence. This is a total classic, a problem you'll see in exams all the time because it really tests if you understand how offers and counteroffers work. The sequence of who said what and when is everything. So looking at how this played out, do you think we have a binding contract? Well, to figure this out, we just have to look at the Indian Contract Act. Section 2B is your key here. It says that an acceptance must be absolute and unconditional. This means a counteroffer isn't just a part of the negotiation. In the eyes of the law, it's a flat-out rejection. It completely destroys the original offer. Let's just walk through the sequence. A's first offer for $75,000 was perfectly valid. But the second B came back with a counter of $60,000, that original offer was legally terminated. It vanished. So when B then tried to agree to the $75,000, they weren't accepting anything. They were actually making a brand new offer, one that A had every right to refuse. So the big takeaway for your exams is crystal clear. Once a counteroffer is made, you can't go back and accept the original offer. That ship has well and truly sailed. No contract was ever formed. All right, let's tackle another huge area of contract law, agreements with minors. This is a topic where the law steps in to provide a really strong protective shield for young people. This problem gets right to the heart of what happens when one party doesn't have the legal capacity to make a contract. What's the legal position when a shopkeeper makes a deal, totally unaware that the person they're dealing with is a minor? On this, the law is completely unambiguous. Section 11 of the Indian Contract Act states it plainly. A minor is incompetent to contract. The groundbreaking case you need to know is Mohiri BB versus Darmodascos. This case is so important because it established that an agreement with a minor isn't just voidable, it's void ab initio. That's Latin for void from the very beginning. It's treated as if it never existed at all. And for your exam answers, you'll want to mention these 3 related doctrines. First, ratification. A minor can't make the void agreement valid just by approving it after they turn 18. It's impossible. Second, estoppel doesn't apply. This is a big one. Even if the minor lied about their age, they can still use their minority as a defense. The contract is still void. The only glimmer of hope for the other party is restitution, where a court might order the minor to return the specific goods, but only if they can still be traced. So in the end, it doesn't matter that the shopkeeper didn't know B was a minor. His ignorance is legally irrelevant. The agreement has 0 legal standing, which means the shopkeeper has no legal right to sue for the price. This brings us perfectly to a really important distinction you have to understand: the difference between a contract that is void and one that is voidable. A voidable contract actually exists, but it's flawed because one party's consent wasn't freely given. Getting this straight is absolutely fundamental. A void contract, like the one we just saw with the minor, is a total legal nullity from the get-go. But a voidable contract is different. It's a valid contract until the wronged party decides to cancel it. The power is entirely in their hands. They can choose to either get out of it or stick with it. This is obviously an extreme example, but it's a textbook case of coercion. It perfectly demonstrates a complete lack of free consent, which, according to Section 14 of the Act, is the absolute bedrock of any valid contract. The law here is incredibly clear. Section 15 of the Contract Act defines coercion as threatening to do anything forbidden by the Indian Penal Code, like pointing a gun at someone. And Section 19 provides the powerful remedy. It makes the entire contract voidable at the option of the person who was coerced. And there you have it. The result is that B holds all the cards. The contract is voidable at their option, which means they can legally cancel it and simply walk away free of any obligations. Okay, we've covered a lot of ground. Let's pull it all together into one final rapid-fire revision list to get you ready for your exams. So let's lock this in. Remember, social agreements, they lack legal intent. Just think Balfour v. Balfour. A counteroffer, it completely kills the original offer. That's your Section 2B. A minor's contract, it's void ab initio under Section 11, with Mohiri Bibi as your key case. And finally, if consent is messed with through coercion or fraud, Sections 15, 17, and 19 kick in to make the contract voidable, putting all the power with the innocent party. Nailing these points and their sections is the foundation for answering any problem question that comes your way. As you finish your revision, I want to leave you with a bigger idea to think about. Notice how all of these rules are part of a delicate balancing act. The law is always trying to create certainty in contracts while at the same time protecting vulnerable people from being exploited. Understanding that underlying why, that tension, is what will elevate your answers from just being good to being truly excellent.